A very good afternoon to all our participants. We thank you for joining us on this special webinar on budget amendments vis-a-vis anti-dumping duty and CVD, jointly presented by Taxsutra and BDO India. Our speaker for today's session is Mr. R. Parthasarathy. Mr. Parthasarathy is an advisor with the Indirect Tax practice at BDO India with a focus on customs and foreign trade policy. He has over 45 years of experience across trade remedy laws, tax litigation, and consultancy in the domains of GST, customs, excise, service tax, VAT, and income tax, IP litigation, and advisory. He is an advocate on record for the Supreme Court and a patent agent since 1996. He has served as the Deputy Secretary and Director, Ministry of Commerce, Deemed Exports and Anti-Dumping. He has held various positions such as Assistant AG and Deputy AG Tamil Nadu, Deputy Director of Audit, Integral Coach Factory Chennai, Deputy Secretary and Director, Ministry of Commerce, Gems and Jewelry, Deemed Exports and Anti-Dumping. He has also been the member of the Audit Board and the ex officio Principal Director of Commercial Audit Tamil Nadu, Auditor for auditing the accounts of UN Headquarters, New York, and much more. He has delivered over 150 lectures, seminars, and webinars. Before I hand it over to Sir, I would like to take the opportunity to apprise all of you that in the last 10 minutes of the session, we will host a dedicated question and answer session. For this, you may post your queries in the Zoom question and answer box. With this, I now hand it over to Sir.
Thank you, Tanaya. Thank you. Good evening to all of you. Today's session is on a very, very specific topic, which is Union Budget 23-24. There are certain proposed amendments to sections 9, 9A and 9C of the Customs Tariff Act 1975. I will deal with those amendments and the implications of those amendments, which are very relevant for the practitioners in that area. And what I've done is to divide my short presentation into 5 broad areas. I'll start with the background of the anti-dumping law, just to put the context in position, not anything to do with the complete development of the anti-dumping law and all that. It's just the background to appreciate this particular subject. Then I'll immediately come into what are the proposed amendments. Then I will deal why are these amendments proposed. That too, these are made with the retrospective effect from 1995. Therefore, what are the implications and way forward? So these are the 5 broad areas in which I propose to cover my topic. After that, we'll follow it with a question and answer session. Next slide. Now, in the background, I just want the people to appreciate that in 1994, when we started the Uruguay round of trade negotiations, which ended in 1994, and with the setting up of the WTO on the 1st of January, 1995. That's the reason why we are talking about 1995. And even before the Uruguay round, under the GATT 1947, or now we call it the GATT 1994, we had an Article 6 containing just about 7 paragraphs, which dealt with anti-dumping and also exports which are subsidized, and therefore countervailing measures to be taken against those subsidized exports. So subsidies and countervailing measures and anti-dumping were dealt with in a very short system of 7 paragraphs in Article 6. Therefore, there was a need to have detailed procedures with reference to anti-dumping and subsidies and countervailing measures. So separate agreements on implementation of this Article 6, etc., were brought into force. So when we had the Uruguay round concluded, we had what we call as the agreement on implementation of Article 6, which is what we normally refer to as the anti-dumping agreement. Now, when this agreement came into force, there are a number of clauses, including how to conduct the investigations, all that. We are not getting into that. But 3 important articles are to be dealt with. One is, there is an Article 18.4, which says that any country which has an anti-dumping law, it must be in conformity with the anti-dumping agreement. All these are important when I'm going to deal with those amendments. Second is, Article 13 provided that every country which has an anti-dumping law must also have a provision for judicial review of the administrative actions which are taken for imposition of anti-dumping duty. And there's an Article 9.1 on imposition and collection of anti-dumping duty. There, the first paragraph of Article 9.1 is also very critical to appreciate the amendments which are currently being made. So I'm going to deal only with these three articles first to set the background and then go into the actual amendments. Next slide. Now, when we come to Article 18.4, it simply says, each member, that is member of the WTO, shall take all necessary steps of a general or particular nature to ensure that from the date of entry into force of the WTO agreement, all its regulations and administrative procedures are also in conformity with that. And that is why in 1995, we amended the Customs Tariff Act by introducing Section 9 for countervailing duties on subsidized articles. Section 9 capital A is reference to anti-dumping duty on dumped articles. Section 9B talked about whether it's subsidy or a countervailing measure. In most of the cases, it must also have to be dealt with material injury or causal link. Dumping per se or subsidizing exports per se is not illegal, but it becomes actionable when it causes material injury to the domestic producer in the country, and there is a causal link between the dumping and the injury, or the subsidized exports and the injury. Therefore, 9B talked about material link, injury and causal link. And Section 9C talked about appeal procedures. Now, these are the broad sections under which everything is built. Then many of the things were left for the rules. And as many of you know, we had the 1995 rules on customs tariff, identification, assessment, collection of anti-dumping duty on dumped articles, and determination of injury rules, 1995, under which the entire procedure is undertaken. Therefore, Article 18.4 of the anti-dumping agreement was fulfilled by India in terms of Section 9, 9A, 9B, 9C, along with the relevant rules. I've dealt with only the anti-dumping rules. So you have a subsidy rules. For safeguard, another trade measure, you have separate safeguard rules also, but those are not necessary for the present discussion. Next slide. Now, this 9.1 is also important. Paragraph 1 of 9.1. See, the decision whether to impose or not to impose anti-dumping duty in cases where all requirements for the imposition is fulfilled, and whether the anti-dumping duty should be equal to full margin of dumping or less, or left to the discretion actually of the importing members. Then, of course, there's always a recommendation that if the duty less than the dumping margin is adequate to remove the injury, then that should also be done. This is a 9.1. This means while there are very set procedures for imposition of anti-dumping duty on dumped articles, the discretion is still given to the individual countries. Even if you find that there is dumping, you find that there is a material injury and there is a causal link between the dumping and material injury, the country may decide still not to impose duty. It is its right. That permission is granted by Article 9.1. That's very, very important. Second, of course, is, as many people know, what the amount of anti-dumping duty cannot exceed the margin of dumping, but it can be less than that. So that provision is there. India had followed what we call as the lesser duty rule, and we have provided that if a duty less than the dumping margin is adequate to remove the injury, that should be imposed. So we have the Article 9.1 specifically empowers a country from not imposing anti-dumping duty, even if all requirements for imposition of anti-dumping duty are satisfied. Now, this is a very, very important provision, which is what we are going to deal subsequently. Next. Then judicial review comes. Then the anti-dumping agreement also provides that wherever you have a legislation on anti-dumping measures, you must also be provision for appellate procedure. It may be an appellate tribunal or a court or anything. That is for the prompt review of the administrative actions regarding the final determination of the anti-dumping duty, review, which can be a midterm review or it can be a sunset review of any of these things. And those tribunals, etc., should be independent of the authorities making the decision. That's why we have the Director General of Trade Remedies, which is under the Ministry of Commerce. The Customs Tariff Act and the allocation of business rules is within the Ministry of Finance. They impose the duty, and the appeal procedure is with reference to Customs, Excise, and Service Tax Appellate Tribunal. We are going to see in Section 9C. So we are fulfilling the requirement of Article 13 through Section 9C, and we are fulfilling the conformity of our laws under 18.4 from Section 9, 9A, 9B, etc., and also through the rules. And the discretion, even if you conduct all the investigation, whether to impose the duty or not, is purely with the respective countries. So this is the background which I wanted to provide before I go into the actual amendments. Please. Now let us look at the amendments. Now section 9C, I'm taking 9A and 9B a little later, but I'm taking section 9C. That's very important. In 9C1 and 9C2, 9C3, certain amendments have been made. Now this has to be carefully appreciated. 9C1 says, originally, an appeal against the order of determination or review thereof shall lie to the Customs, Excise and Service Tax Appellate Tribunal. 9C2 says, every appeal should be filed within 90 days of the date of order under appeal. And 9C3 says the appellate tribunal may, after giving the parties, etc., pass an order confirming, modifying, annulling the order appealed against. Now what we are having is, in 9C1, the word order of is removed. So it now reads as an appeal against the determination or review shall lie with the Customs, Excise and Service Tax Appellate Tribunal. Every appeal should be filed within 90 days of the date of determination of review. The appellate tribunal may modify the determination or review appealed against. So we do not refer to the word called order of determination or review. It is simply determination or review. Now, therefore, what is determination? What is review? An explanation has been inserted in section 9C5. And the explanation says, for the purposes of this section, determination or review means the determination or review done in such manner as may be specified in the rules made under section 8B, 9, 9A and 9B. Now, what is it? Therefore, first is determination or review has a very specific meaning. That meaning is what was the determination or review contemplated under the rules. Now, under the rules, if you go, we talk about the Director General of Anti-Dumping. Now it is Director General of Trade Revenues and Trade Remedies, and they are the ones which will do the determination, or they are the ones who will come with the review. So the meaning of section, the determination or review is now made specific to the determination or review determined under the rules. Whereas originally, we are going to see that slightly later. Originally, when we had the word order of determination or review, the order was always talked about in the context of the final imposition of the anti-dumping duty by the Ministry of Finance based on the recommendation made by the Director General of Anti-Dumping or the Director General of Trade Remedies. So now the significant change which has come about in section 9C1 to 9C3 is the appeal is against the determination or review, and the determination or review is by the authority appointed under the rules, which is the Director General of Trade Remedies. Therefore, the Ministry of Finance does not come into the picture as far as the determination of review is concerned. And this, why this amendment is made, we will cover slightly later. So this is the implication of what has been now sought to be done is that there is a specific meaning which is assigned to determination of review, and that determination of review is what is appealable to the CSTAT. Next slide. Similarly, what we have in section 9A, which deals with anti-dumping, provided that if the central government in a review, so instead of in a review, they are now substituting it on consideration of a review. Now we can say review means review determined under the rules. Who determines it? It is the DGTR who determines it. Therefore, the recommendation of the DGTR is what is on consideration of the review of the central government. Now, whenever we talk about the central government, as you all know, in the context of Custom Tariff Act, under the allocation of business rules, it is the Ministry of Finance we are talking about. Whereas when you come to the Commerce Ministry, if you're talking about central government, we are under allocation of business rules, it will be the Ministry of Commerce. But because this is a Customs Tariff Act, which is under the Ministry of Finance, the Ministry of Finance says, I am not doing the review, provided that is central government in a review, not the Ministry of Finance, but the Ministry of Finance will, on consideration of a review, something happens to be done, they may do. Similarly, 9A6 also, the margin of dumping shall be ascertained and determined. That is how it was. It will be ascertained and determined by the central government, which means when the actual anti-dumping duty is imposed by the Ministry of Finance, that is what is the stage of ascertainment and determination by the central government. Now they are only saying, delete the words undetermined. It is be ascertained by the central government. It is ascertained by the central government on consideration of the review which is undertaken under the rules by the DGTR. So in a way, the amendments in 9A5 and 9A6 are vesting everything, the determinations, etc., with one authority, DGTR, and consideration of those determinations or reviews is what is with the Finance Ministry. So this is also in line with what we saw under Section 9C earlier. So this also follows the same pattern. Next slide. Then similarly, the first proviso to Section 9(6) of the Custom Tariff Act also provided that if the central government in a review, so instead of that, they mean on consideration of review, this is what we call the recurrence of subsidization and injury. It may extend that time. Similarly, 9(7), they talk about this is a subsidy portion. 9A was anti-dumping, 9(6) and 9(7) are in the context of subsidized articles. There also, the word ascertain and undetermined is removed. So the amendments in 9(6) and 9(7), which deals with subsidized articles, is pari materia with the amendment which have been made in Section 9A, which deals with anti-dumping, which means the central government shall only ascertain. And the ascertain is based on a review determined by the DGTR, and the central government, which is the Ministry of Finance, will, on a consideration of that particular review, determine whether something should be done or not. That's the implication of what we have seen so far in 9A and 9C. Next slide. Now we come to why these amendments have been made. Now, for that, we'll have to go back to the history to look at what is happening. When our law was enacted from 1st January 1995, and from 1995 to 2019, we have conducted hundreds of investigations. In fact, India is a very, very big user of the anti-dumping regulation. And we have been performing the requirements as is required. Between 1995 and 2019, when I'm talking about hundreds of such investigations have been conducted and recommendations have been made by the DGAD or the DGTR, most of these recommendations have been accepted by the Ministry of Finance, and notifications have been, please go back. I don't know where it's coming. Notifications have been issued very clearly implementing those recommendations. There are only 4 or 5 cases where the recommendation of the DGTR was not accepted by the Ministry of Finance in that 24 years period. Now, contrast that with what has happened in 2020, 2021, and 2022. 3 years. In this 3 years, there is a sea change. And by that, I mean, there are more than 150 cases in which a positive recommendation has been made to the DGTR, but those recommendations have not been accepted by the Finance Ministry. In fact, it's around 50 cases in the first 2 years and more than 80 in the 2022. So we are talking about 170, 180 cases in which the Ministry of Finance did not accept the recommendation. And what we know is there is only in the website a letter is put, and that's what is communicated to all them. Generally, the verdict is that the central government, after considering the final findings of the designated authority, has decided not to accept the aforesaid recommendation. That's all. All that we get to know is that it has been decided not to accept the aforesaid recommendations. Why, etc., no reasons are being given, even though the rejection rate is far significant in the last 3 years than it has been in the last 25 years. Obviously, people are unhappy. You could say practitioners in this area know when anti-dumping investigation takes between 12 to 18 months to conclude, and there are very elaborate procedures for the petitioner, the domestic industry in India, to make a petition giving a prima facie case of dumping, injury, and causal link, which is examined. Then only an initiation takes place. Then exporters from various countries participate. They provide information on a complicated questionnaire. The importers in India, who are also affected parties, they participate. There is a public hearing. There is a preliminary finding. There is a verification of the information, and then there is a final finding. So it's a very, very elaborate procedure involving enormous amount of resources being spent by the DGTR and its officers, by the domestic industry and its consultants, the exporters and the consultants, the importers and the consultants, lot of effort. And after all that effort, if a final finding of a positive dumping and injury and an anti-dumping duty is recommended, if these are not accepted in majority of the cases, it also means that there is a lot of uncertainty for the domestic industry and the enormous amount of wastage of resources. And obviously, therefore, if the recommendation is positive and it is not implemented, okay, the exporters are happy, the importers are happy, because importers bear the brunt of duty, exporters lose the market, and the domestic industry is not able to raise the price. The real person who is affected if the recommendation not accepted is the domestic industry. The exporters and importers, they have spent time and effort, fine, but at the end of the thing, at least they don't have a duty, and therefore their market is not disturbed. So the in this type of situations where the recommendation is not accepted, it is the domestic industry which is affected. So what do? Obviously, they challenge this type of decision not to accept the recommendation before the CSTAT. That's what we are going to see. Now, what did the CSTAT do in such type of cases? Let's look at the next slide. Now, many of these decisions, as I said, which are not accepted, are appealed in the CSTAT. On 23rd December 2022, in the case of Reliance Industries with Union India, the CSTAT had, I'm not exactly everything, is paragraph 49, because they have already done similar types of orders, passed similar type of orders in earlier cases where the Ministry of Finance had not accepted the recommendation. And what they have said is, this office memorandum saying that it has been decided not to accept the recommendation is set aside. And the matter is remitted to central government to consider the recommendation made to the DA in the final findings in the light of the observations, etc. Therefore, what the CSTAT has done is to send the back matters to the Ministry of Finance, saying you must consider them in the light to reconsider the recommendation. What are the things which I have to tell you is, when this goes to the CSTAT, the general stand which is taken by the Ministry of Finance is that the recommendation is by the DGTR. The decision whether to accept the recommendation or not rests with the Finance Ministry, and that decision is like a legislative function, and therefore it is not subject to judicial review. Whereas the CSTAT has held that what you are performing, Finance Ministry, based on the recommended DGTR, is more like a quasi-judicial function. Therefore, you are bound to give valid reasons for the decision not to accept the recommendation of the DGTR. So that's where the tussle is between the tribunal recommendation and the stand of the Finance Ministry. Next slide. Now, some of these CSTAT orders are under challenge by the Minister of Finance in Delhi High Court. I have given two examples, for example, Jubilant Ingravia and then Association of Synthetic Fiber Industry. And in all this, as I pointed out, Ministry of Finance contends that the acceptance or otherwise of the recommendation is a legislative action and not a quasi-judicial action. So the decision of the Ministry of Finance cannot be challenged in any court and is not amenable to judicial scrutiny. Now that's the thing where the thing stands. Now it is in this context, I think we'll have to then understand what has happened, why these amendments have been brought into force. Next slide. Now, if you read the proposed amendment in section 9C, and more important, read it with the explanation, it makes it clear that the determination or review refers to the determination or review undertaken under the rules. And we all know that the determinations or reviews are therefore made by the DGTR. Under the rules, DGTR is the one which makes it. And therefore, this amendment, when it becomes a Finance Act, and it has retrospective effect from 1/1/1995, makes what is appealable to the CSTAT is the determination or review finding of the DGTR and not its acceptance or otherwise Ministry of Finance. So what we are now saving the situation is, if this amendment goes through and subject to challenges, we'll come to that. What is the position is the action of the Finance Ministry is not amenable to appeal procedures of the CSTAT. What is appealable is only the finding of the DGTR, or what we call the recommendation final finding, which is a recommendation of central government that anti-dumping duty should be imposed on such and such goods, on such a country, such and such an exporter at this rate, etc. That is what is appealable and not the final decision of the central government. That's the central government, I mean, is finance ministry. This is the implication of the current amendment which is made. And therefore, it will more or less say all orders of CSTAT and the challenges before the High Court, etc., will be said. Now, because of this retrospective amendment, the decision of the finance ministry is not appealable. Therefore, all these appeals and writ petitions, etc., or OTOs, you please dismiss them. That's what is the position which we are coming to. Next slide. Now, before do that, I also wanted to highlight a very interesting decision in Saurashtra Chemicals, which is reported in 118 ELT 305, which I had the occasion, I was present in the Supreme Court when this was done. Now, this is the order itself is only these 5 lines. And when this was again, for many practitioners, but others, when in 1995, when this law was introduced, and whenever a final finding was given, people immediately will challenge the final determination before the CSTAT under section 9C. On the ground, the determination has been made by the DGTR that there is anti-dumping, there is material injury, there is causal link, and therefore anti-dumping should be imposed. So then people tell the anti-dumping duty should not be imposed because there is no material injury. Or the exporter will say, my dumping margin is not 18%, but only 8%. You have made this mistake. All those things were challenged. And CSTAT was also dealing with all those appeals. But when one such appeal after that came to SLP, the Supreme Court held like this. You see, we see no reason whatsoever to entertain this special leave petition. Leave that. It is perfectly clear now that we have seen the provisions of the Act that the order of the designated authority is purely recommendatory. The appeal that lies is against the determination, and that determination has to be made by the central government. For this reason, we decline to exercise jurisdiction under Article 136 and dismiss the special leave petitions. So what is important is this. The Supreme Court held it is not the designated authority's final finding which is appealable. It is the implementation of this recommendation by imposition of anti-dumping duty by the finance ministry which is appealable. Which means if there is no positive recommendation, there is no customs notification implementing this recommendation, then appeal will not lie. In fact, because of this judgment, all of us were made to implead the customs notification as part of the appeal, and then the appeals were argued, and subsequently, of course, appeals will be filed only after the Ministry of Finance issues the notification. So now, therefore, what was held by the Supreme Court was its final recommendation which was appealable and not otherwise. Now, what we are now is a situation is because the word determination and the determination has to be made by the central government, they are now said the determinations or reviews means determination or reviews made under the rules, which means DGTR. So that is what is appealable and not what the final decision of the central government, which means you can appeal to the CSTAT as soon as the final finding comes within 90 days of the final finding without waiting for the implementation. But if it is not implemented and yet the appeal is maintainable, what is the purpose? That's what we are going to say in the implication of the next slide also. So it's very interesting that in Saurashtra Chemicals, the Supreme Court held what is really appealable is the order of the finance ministry implementing the recommendation. Now, if that is now being stated as a legislative action and is beyond the jurisdiction of judicial review, then to some we are finding the Saurashtra Chemicals is thought to be overturned through this particular process. We'll see that. Now, therefore, whether the amendments seek to overcome Saurashtra Chemicals, I don't find anywhere that people talking about Saurashtra Chemicals. It is generally the point which is being talked about is determination or review appealable is that of the designated authority. The action of the finance ministry is purely legislative is what. But the Saurashtra Chemicals said that is not legislative. Implementing it through recommendatory is what makes the entire process appealable. That is also true because if the recommendation is not implemented, what happens? There is nothing you can appeal. Suppose this is what now it is by making. Suppose I go and appeal. The final finding is the resignant authority. But in any case, Finance Ministry has said within 3 months that it is not going to implement it. And let us say I succeed in the CSTAT. What do I get? When they have decided not to implement it, are we rendering the appeal provisions OTOs? So that is though the very significant implication of this amendment is one. Finance Ministry decision is sought to be taken outside judicial purview. And what is sought to be brought within the judicial purview is only the recommendation of the DGTR. But if it is not implemented, an appeal to CSTAT against the final finding is absolutely practically of no use. As I said in one of my articles, it's just like operation successful, patient died. So why would even a CSTAT go into that recommendation and say what you did is wrong, it should not be 10, it should be 8, etc. Any 10 or 8, it is not implemented. So where is the question of going on appeal, etc.? Therefore, the present amendment, by making appeal of the recommendation only, but not of the decision, and if the recommendations are not going to be accepted in such huge numbers as is happening in the last 3 years, then we are in a situation where the appeal procedure is also OTOs, and the decision of the Finance Ministry is also not liable to be taken up in judicial scrutiny. So anti-dumping, I would say, after 25 years, 28 years, is again at the crossroads. Can you go to the next slide, please? Therefore, we are in for definitely another round of litigation. Whether this first, to challenge the legislation and to say that it cannot be done, maybe in my view, that's going to be very, very difficult, because all legislations presumed to be, intra-vires and everything, not a problem. But whether an accepting or not accepting a recommendation of the DGTR, which by law we have split into two, one portion being done with the DGTR, one portion by the Finance Ministry. By doing that sort of a thing, whether we can render the entire process, useless for the stakeholders in this case, mainly the domestic industry, because this is a legislation which is for protecting the domestic industry subject to satisfying certain requirements. As I said at the beginning, neither the importers nor the exporters are to be unhappy if a recommendation is not implemented, but it is going to affect the domestic industry. Therefore, there is definitely bound to be a litigation, both on the proposed amendments and also the view whether this could be treated as a legislative function and therefore it cannot be subject to judicial scrutiny. I think we are definitely going for a round of litigation, and that's probably to be settled only at the Supreme Court level. But till then, if the once in by about May or so, when this finance bill comes into an act, and if the Finance Ministry is not going to implement a recommendation, then practically there is no remedy for the stakeholders in this anti-dumping investigation. Can we just go to the next slide? I think that's it. So I've concluded very short this thing. I think I generally know a lot of people here would know the background. So I just touched on the most important issues. I'm definitely happy to answer some questions.
Thank you, sir. Thank you so much. Listening to you is always a pleasure, sir. The way you dissect the topic and, the way you get into the finer issues, sir, it's really a pleasure to hear you. We also have comments saying, sir, you are excellent as always. So I think that says it all. Sir, currently we don't have any questions.
Okay.
But sir, if at all we receive any, we'll definitely sort of flag it off to you. Is that okay, sir?
Yeah, absolutely. Not an issue at all. Absolutely. Yeah.
Sure, sir, sure.
Yeah.
Also, one of the participants has asked about the presentation. So I'll just like to make an announcement. Post 48 hours of this session, we will be uploading the recording, the webinar recording on taxsutrareservoir.com, which is Taxsutra's platform for e-learning and ebooks. So I request everyone everyone to log into www.taxsutrareservoir.com to get access to the pre-recorded session as well as the presentation.
Yeah. Now, just one question which has come in the chat box
Right,
for me
right,
from Mr.
right,
Rajesh.
right.
Yes, of course, I didn't touch on that provisional assessment, but I don't know this outside. See, both even in the finance ministry, when the appeals had gone, writ petitions had gone to Delhi High Court, also had given such an order saying because till we decide, but after we decide, by the time if the assessments are final and then you can't reopen because of the time limits, etc., and if anti-dumping duty is has to be imposed according to the directions of the Delhi High Court, and by the time you will not be able to do, therefore they have tried to protect the interest by saying, okay, in these cases, the assessments may be kept provisional, subject to outcome. If, of course, the outcome they say that we'll have to, impose the duty, then you will be able to collect it because the assessments are provisional. The question here is, um, how can we ensure that proper implementation of the order with ISCAI? I think it's more a question of procedure. One is, of course, definitely you'll have to ensure, somehow we allow to ensure that the ordering provisional assessment in such types of cases has to be brought to the notice of all the customs formations, and it is put on the IceGate notification so that it pops up every time if the subject goods come. And as a practitioner in charge of, if I say, domestic industry, you will have to do a little extra work to ensure that it is noted by all the assessing officers, and assessments are done provisionally. It's a little difficult issue, but now with IceGate and also implementing everything through the electronic system, that should not be a problem. I'm only hoping that proper instructions go. So you'll have to definitely ensure that once that type of order has come, you communicate it to the through the CBICs. That's important, because if you communicate something, I don't think anybody is going to listen. So it's important that such communication goes from the CBIC, and you will have to follow up the CBIC to ensure that it is communicated, and it is also put on the IceGate monitoring system to ensure that provisional assessment takes place. Yeah.
So we do have a couple of questions.
Yeah.
Mr. Rajendra Sharma is asking, we have recently received a CESTAT order to
Mm-hmm.
Finance Ministry to review.
Ah.
Will that order also be void now?
Yeah, see, what we have done in all these cases where a review, they asked a review, what Finance Ministry is doing, as I said, is simply challenging that order in the Delhi High Court, saying that their action is legislative and therefore they are not bound to review or to give any reasons. That's what. Suppose they will file another writ petition and tag it along with the Association of Synthetic Fiber and others, they will tag it along for a final decision. But once this amendment is passed, becomes a Finance Act, my guess is that they will move it to the Delhi High Court, saying you dismiss all these writ petitions because the amendment made, these are not liable to judicial review, and I'm not bound to give any reasons, etc. So this must be dismissed. So that's what they're likely to do after the finance bill becomes the act.
Right, sir. So another question is coming from Mr. Nitin Goel. He says, in case of a positive order from the DGTR but not notified by the central government, whether the writ petition would be maintainable by the domestic industry. He also adds to that and says, since because of positive determination by DGTR, there is no cause of action for appeal by DI.
Yeah, see, that's a major problem. See, every time the law says within 3 months from the date of the recommendation, the finance ministry should issue. If they don't issue within 3 months, it means that the recommendation is gone. Therefore, you don't have any action. The only way we have to do it is through a writ petition. And in the writ petition, yes, you don't have a cause of action in the sense that against the DGTR, but you have a cause of action against the finance ministry for not implementing the order. Therefore, we've always been challenging, but then the problem, as many of you know, when it comes to writ petition, is the scope of the inquiry which the court will conduct in a writ petition, unlike an appeal procedure, is limited. So the only way in which those could be succeeded, of course, always make the finance ministry a respondent and say you're actually asking them for a writ of mandamus, compelling them to accept a positive recommendation, unless they are able to come out with reasons which stand for judicial scrutiny, which is what now they are trying to overcome through this particular amendment. It will be like more like what we call DGTR as a pro forma part, in the sense that you are not seeking any relief against them, but you are seeking a relief against the finance ministry.
Right, sir. So those were the questions for today. So yeah, the participant said thanks to you, sir, for answering that question. We also have another comment which says, great informative session. Thank you. So, sir, with this, would you like to maybe share some closing remarks, or should we close the session?
At this point, I'm very happy. I'm thankful to you, Taxsutra, for giving me one more opportunity of addressing my colleagues through this platform. I'm happy to share my experience on this particular issue, and that's why I said it should be a short session of not more than 45 minutes, and then I think we are around 41 minutes is what we have covered. Yeah, thank you very much for the participants for their great interest in this session. Thank you.
Thank you very much to you, sir, for putting in, and I mean, you're shedding so much light on this topic. It was truly an enlightening session. So thank you so much, sir. As usual, it's always a pleasure to listen to you. And sir, we really look forward to hosting you again on some other riveting topic or some other time. Thank you, sir. Thank you. Many thanks.
Thank you, everyone. Bye. Have a nice evening.